Hi. Let's learn about the force majeure contract clause and how it works. Today, we will talk about a force majeure clause is included in contracts to remove liability for unforeseeable and unavoidable catastrophes that interrupt the expected course of events and prevent participants from fulfilling obligations. These clauses generally cover natural disasters, such as hurricanes, tornadoes, and earthquakes, as well as human actions, such as armed conflict and man-made diseases. Force majeure is a French term that literally means greater force. It is related to the concept of an act of God, an event for which no party can be held accountable, such as a hurricane or a tornado, but it also encompasses human actions, such as armed conflict. For events to constitute force majeure, they must be unforeseeable, external to the parties of the contract, and unavoidable. These concepts are defined and applied differently depending on the jurisdiction. Force majeure conflicts with the concept of pacta sunt servanda, a key concept in civil and international law with analogues in common law. It is not supposed to be easy to escape contractual liability, and proving that events were unforeseeable, for example, is difficult by design. The concepts underpinning force majeure are shifting as we become increasingly aware of natural and human threats. For example, an avalanche destroys a supplier's factory in the French Alps, causing long shipment delays and leading the client to sue for damages. The supplier might employ a force majeure defense, arguing that the avalanche was an unforeseeable, external, and unavoidable event. The court may well decide that the supplier owes damages unless the contract specifically named an avalanche as removing the supplier's liability. The International Chamber of Commerce has attempted to clarify the meaning of force majeure by applying a standard of impracticability, meaning that it would be unreasonably burdensome and expensive, if not impossible, to carry out the terms of the contract. Proving these conditions can be challenging, and most force majeure defenses fail in international tribunals. Contracts containing specific definitions that constitute force majeure, ideally ones that respond to local threats, tend to hold up better under scrutiny. Here are 5 key takeaways. 1. Force majeure removes liability for unforeseeable and unavoidable catastrophes that interrupt the expected course of events and prevent participants from fulfilling obligations. 2. Force majeure generally covers both natural disasters and catastrophes created by humans. 3. In some jurisdictions, force majeure is determined by whether the event is unforeseeable, external, and irresistible. 4. Increased awareness of pandemics, asteroids, supervolcanoes, cyber threats, and nuclear warfare has raised questions about what is and is not foreseeable in a legal sense. 5. Force majeure conflicts with the principle of pacta sunt servanda, which states that agreements must not be wriggled out of. Hope this would help. Thanks for watching.